The Companies Act of 1956, Section 42, Membership of Holding Company. Subsection 1 of Section 42. Except in the cases mentioned in this section means Section 42. Except in the cases mentioned in this section, a body corporate cannot be a member of a company which is its holding company. So a body corporate cannot be a member of a company which is its holding company. A body corporate cannot be a member of its holding company. Means a body corporate cannot hold any shares of its holding company. This is what this subsection 1 of section 42 enable us to understand. A body corporate cannot be a member of a company which is its holding company. And second point in subsection 1 is any allotment or transfer of shares in a company to its subsidiary shall be void. A holding company cannot allot any shares to its subsidiary. A holding company cannot transfer any shares to its subsidiary. If this transacts, the transaction shall be void. That is, refresh ourselves. Any allotment or transfer of shares in a company to its subsidiary shall be void. This is second point in subsection 1 of section 42. There are 2 points in subsection 1 of section 42. That is, refresh ourselves. First point in subsection 1 of section 42, except in the cases mentioned in this section, a body corporate cannot be a member of a company which is its holding company. This is first point. A body corporate cannot hold any shares of its holding company. Here body corporate refers companies. You may recollect very well the definition of body corporate. So here in clause 7 of section 2, let's recollect a definition of body corporate. Clause 7 of section 2 of the Companies Act 1956. Body corporate or corporation, both expressions, includes a company incorporated outside India. Includes a company incorporated outside India, but doesn't include a corporation soul, doesn't include a cooperative society registered under any law relating to cooperative societies and any other body corporate, not being a company as defined in this act, which the central government may by notification in the official gazette specify in this behalf. This is how expression body corporate or corporation is defined in clause 7 of section 2. Let us refresh again. Body corporate includes a company incorporated outside India. So here it is implied companies incorporated India are also may be termed body corporate or corporation. This is synonymous. Let us go to our section 42, membership of holding company. Except in the cases mentioned in this section, a body corporate cannot be a member of a company which is its holding company. This is first point. Second point is any allotment or transfer of shares in a company to its subsidiary shall be void. So a company which is holding, which is a holding company, cannot transfer its shares to its subsidiaries, cannot allot any of its shares to its subsidiaries. This is what subsection 1, section 42 enable us to understand. There is another point. A body corporate, a holding company, cannot be a member of its subsidiary company. So let us go to subsection 2 of section 42. Nothing in this section shall apply where a subsidiary is concerned as a legal representative of a deceased member of the holding company. In such a case, a subsidiary company can continue to be a member of its holding company. Of course, it appears that it is contradicting subsection 1 of section 42, but there is some proviso where it can take place. That is, if the subsidiary is concerned as a legal representative of a deceased member of the holding company. There is another point in subsection 2. Nothing in this section shall apply where the subsidiary is concerned as trustee. Nothing in this section shall apply. This is second exception. Nothing in this section shall apply where the subsidiary is concerned as trustee. Unless the holding company or a subsidiary thereof is beneficially interested under the trust and is not so interested only by way of security for the purposes of a transaction entered into by it in the ordinary course of a business, which includes the lending of company. So in these two exceptional situations, section 42 shall not apply. Let us refresh what are these two exceptional situations available in subsection 2 of section 42, where section 42 shall not apply. What does it says? The section 42, subsection 1 of section 42 says, except in the cases mentioned in this section, a body corporate cannot be a member of a company which is its holding company, and any allotment or transfer of shares in a company to its subsidiary shall be void. This is what section 42 enables us to understand. When it comes to subsection 2, some exceptions we may find. There are two exceptional situations where section 42 doesn't apply. Let us see first exceptional situation where the subsidiary is concerned. Nothing in this section, that is section 42, nothing in this section 42 shall apply where the subsidiary is concerned as a legal representative of a deceased member of the holding company. This one exceptional situation. Let us go to second exceptional situation. Nothing in the section 42 shall apply where the subsidiary is concerned as trustee. Underline the expression trustee. Nothing in this section 42 shall apply where the subsidiary is concerned as trustee, unless the holding company or a subsidiary thereof is beneficially interested under the trust and is not so interested only by way of security for the purposes of a transaction entered into by it in the ordinary course of a business, which includes the lending of money. Let us understand. See, an expression trust is not defined, or we may not find what the Companies Act 1956 means, the term trustee, but the expression trust is defined in the Indian Trust Act 1882. As per section 3 of the Indian Trust Act 1882, a trust is an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner, or declared and accepted by him for the benefit of another, or for the benefit of another and the owner. This is what the trust is defined in Section 3 of the Indian Trust Act 1882. And the person who accepts the conditions or the confidence is called the trustee. Let us go back to our section 42. Subsection 3 of section 42 comes forward to explain us this section shall not prevent a subsidiary from continuing to be a member of its holding company. You may recollect, subsection 1 of section 2 was also in exceptional situation trying to make us understand very thing. That is what subsection 3 of section 42 is also coming forward. Let us refresh ourselves. This section 42, this section shall not prevent a subsidiary from continuing to be a member of its holding company, if it was a member thereof, either at the commencement of this act, or before becoming a subsidiary of the holding company. Assume that X company is holding some shares in Y company. X company is holding some shares in Y company. After passing some period, Y company holds majority of shares in X company. So in such a situation, as X was holding shares prior to the transaction, that is, Y turns as a major shareholder of X. So X can continue to hold shares of Y, though Y holds after some time majority of shares of X. Here, this is what we may understand from subsection 3 of section 42. This section 42 shall not prevent a subsidiary. From what? From continuing to be a member of its holding company. So this section shall not prevent a subsidiary from continuing to be a member of its holding company. In what situations? If it was a member thereof, either at the commencement of this act, one situation, another situation. If it was before becoming a subsidiary of the holding company, but some exception. But except in the cases referred to in subsection 2, the subsidiary shall have no right to vote at meetings of the holding company or any class of members thereof. Let us go to subsection 4. Subject to subsection 2, subsections 1 and 3 shall apply in relation to a nominee for a body corporate, which is a subsidiary, as if references in the set subsections 1 and 3 to such a body corporate included references to a nominee for it. This is very interesting. Subject to subsection 2, recollect, there are some two exceptions given in subsection 2 of section 42. Subject to subsection 2, subsections 1 and subsection 3 shall apply in relation to a nominee for a body corporate, which is a subsidiary, as if references in the said subsections 1 and 3 to such body corporate included references to a nominee for it. Let us go to subsection 5 of section 42. In relation to a holding company, which is either a company limited by guarantee or an unlimited company, the references in this section to shares shall, whether or not the company has a share capital, be construed as including a reference to the interest of its members as such, whatever the form of that interest,